right, so welcome everyone. Good morning. Sorry about the technical difficulties with the PowerPoint. And I'd like to remind John that I will always agree with him when he's right. But that being said, of course, when an attorney gives you legal advice, you follow it. It doesn't matter whether you agree with it or not. I can argue. If I don't win the argument, I follow what John tells me to do because he's an attorney and I'm not. So follow the legal advice that you're given. So I'm going to go into a little bit of the parliamentarian's perspective for avoiding board blunders for this Condorama. And my dad did assist me with this presentation all the way from Argentina. So I do thank him. That's why I put his name there. I thank him for his help on this. Aha. Okay, first up. So the topics that we're going to cover today. So we're going to learn about, so you got elected. Now what happens? It's not all parties and cruises the way that, we would have you believe. It's a bit of work involved. You got to make sure that you're prepared for your board meetings and how your board meeting functions. What are the proceedings, the procedures that you have to follow? If you can please hold any questions that you have until the end. We do have that time for Q&A afterward, and you were also given little question sheets if you wish to fill those out as well. All right, so you got elected. Now what happens? Congratulations, or as many of you have heard me state at meetings where I've served you, my condolences, because it means, of course, that you've just been elected or appointed to a condo PCA Planned Community Association, or sometimes a co-op. So we call these community associations. What does this mean? Did you review the job description before you ran? What about the pay scale? What about the hours of work? Do you get any special privileges? And here I have to say no. It's a volunteer position, which means your pay is zero, and usually it's a generally thankless job. And that's actually something that Gordon pointed out, which is really important, showing gratitude. So if you're not on your board and you're an owner, even if you disagree with your board, still take the time to thank them for the time that they put in, whether or not you agree with their decisions. They're still trying to work on behalf of you and the association. So, for officer positions, again, you also get no special treatment. There was a board that I served where this president thought that he should have the right to look into everyone's units because he was president. No, you do not have that right. And in fact, when you're a board member, and especially an officer, you should be the example. You should definitely never be delinquent on your maintenance fees. Okay? You should observe and comply with all of your governing documents. You should make sure that you don't appear to receive any special privileges. As you heard John state, you do not want to disclose executive session proceedings. That's really important. It can open your association up to liability. So even though a lot of us, I'm on my own condo board and I want to be as transparent as possible and give as much information as I can to all of our owners, there is a limit and you have to watch it. So when your attorney advises you that executive session is private and certain things need to be discussed only there, follow the advice of the attorney. You need to be somewhat familiar, at least with the fact that there are state laws that govern these community associations. There's different ones. You heard them referred to 514B, which is condos. There's 414D, which is generally nonprofit associations. There's 421H, I, J, different styles of community associations. So at least make sure that you're aware that those laws exist. Most of those are really short, a couple pages. It's 514B that's huge. Thank you, Gordon. No, I'm just kidding. You did a great job. Much better than 514A, for sure. There you go. So be aware of state laws, different types of organizations. So governing documents. So as an association, you do need to be aware that you have rules that you need to follow apart from the laws. And sometimes your association will be incorporated, which means you may have a charter or articles of incorporation. You may also have a declaration, especially community associations and bylaws, community associations and condos. Condos will have a declaration because you need to declare it to be a condominium property regime. There's always a declaration for condos. It's required to be recorded by state law. Community associations, the recording requirements are not the same as for condos, so be aware of that. Applicability of any laws must be reviewed with an appropriately licensed attorney. Can't say that enough, because there are some conflicting rules. If you compare parts of 414D, the Nonprofit Act, with 514B, the Condo Act, there are some things that are not quite the same. If you read 514B, you'll find that it does take precedence over 414D, but if you have any specific questions, definitely check with your association's attorney. The list that I've given and that's in the handout is not exhaustive, so there could be more. You might also have house rules, you might have board policies that you need to be aware of. So every board member should make sure they have a copy of all these rules. It's helpful for owners to know the rules, but really as a board member too, again, be that example. You want to make sure that you have those rules at the meeting, whether you bring them, you request your property manager to bring them. On my own condo board, I'm secretary, so I try to make sure that I always have the declaration, the bylaws, and the house rules with me in case anything comes up. So of course, a Parliamentarian's Bible, the Robert's Rules of Order. This right here is the 11th edition. They will be coming out with a 12th edition next year, which means that there will likely be a fire sale on the 11th edition soon. So, you know, the chair is not sure how many things are really going to change. They talked about it a little bit at our Parliamentarians Convention, but they don't tell us too much. They try to avoid changing anything great. What they focus on is clarifying and modernizing. So that's why we now have references to electronic meetings in Roberts, where a few editions ago, there were no such references. So I love Robert's Rules of Order Newly Revised, the full edition. However, for normal people who aren't OCD parliamentarians, this is the book that I recommend you buy. Robert's Rules of Order Newly Revised in Brief. It runs about $8, and I like it because the print, it's much easier to read than this size 0 that's in the big book, and it has scripts that you can use. So you can actually put this into use immediately. It maybe takes the length of an inter-island plane ride to read. I'd say 40 minutes. So much easier to read than the 700 pages that are in Roberts. Your board might be operating under standing and special rules of order. You heard John say different ways that condominiums can adopt rules for their board meetings. And you may want to do so to somewhat control owner participation, since now the state law has made it a lot more unlimited than it used to be. But it still needs to be under control, because the board needs to get the business of the association done. They have a fiduciary duty to the association to make sure they get that business done. So as much as they want to hear input from owners, and they do appreciate it, they still need to get the work done. And no one likes 5-hour meetings. If you do, please do not join my board. Many of the property management companies, they do have access to these books and also to our sample meeting rules that we make. So we have meeting rules for annual meetings, which is generally the most often reason we're called. And we also have board meeting rules that boards can adopt as well. Occasionally I run a condo board meeting here or there, or I go just advise the chair, help the chair run it. Little point of parliamentary procedures. Standing rules are administrative rules, like no smoking, please take your hats off. If it's in a convention style, like delegates need to wear badges, things like that don't necessarily affect a parliamentary rule of order. And special rules of order are rules that affect the parliamentary rules. So for example, in Roberts, the debate limit is 10 minutes. Which means that you have the right to speak for 10 minutes at a time, which made perfect sense in the 1800s, but doesn't make as much sense now in the 21st century, where people are very busy and they have a lot to do, which is why most of our standard sets of meeting rules include a special rule of order stating that speeches shall be limited to 2 minutes. Why 2 minutes? Because that is about the length of time it took Lincoln to state the Gettysburg Address. So we figured not that many people are going to give a speech that important that will withstand that many years, so 2 minutes should be enough for most people. Other rights and responsibilities of board members. Most of the rights attributable to board members occur at the board meeting. So board members are the ones that have rights to make motions, debate, and vote at the board meetings. And these rights can only be interfered with under limited circumstances. So for example, a 2/3 vote to cut debate. We're done talking about this issue, let's take a vote, let's stop debating. That does take a 2/3 vote of the board. Board members must do what's best for the association rather than what's best for their individual interest. Again, they do owe that duty to the association. And this responsibility exists regardless of how the board member is elected or appointed. It doesn't matter if they were elected in owner's meeting or if they were appointed to fill an interim position by the board, they're still responsible. Also, even if you're elected by a particular constituency, like for example, if you have a mixed-use building and you're elected by the commercial owners, it's still your responsibility on the board to represent everyone. Even though a constituency got there, it's still your duty to represent the entire association. Which brings us to an important point. Board members do need to be aware of any possible or perceived conflicts of interest. When in doubt, obtain legal assistance. It's the safest thing. Also, disclose. So the law doesn't necessarily prevent you from voting, although you can be, but you must absolutely disclose a conflict of interest. It's safest if you don't vote. In fact, it's safest if you even leave that portion of the meeting, if you want to make sure you're being as conservative as possible. But number one, disclose. Because then the board may decide, you know, that's not really a conflict of interest. We appreciate you bringing that to our attention, but we don't feel it rises to that level, so we'd like you to stay and vote on this issue. A board or another board member does not have the right to stop another board member from voting unless it's specifically provided in the law or in your bylaws. You can't prevent someone else from voting. There are some relaxed rules for small boards. So most of the associations that I serve professionally have small boards. Roberts considers a small board to be, as he states, not more than about a dozen. That's 12 members or less. So almost all of you would be on small boards then. So for small boards, a number of the rules are relaxed. The president can in fact make motions, debate, and vote. You don't need seconds for anything. However, there are some groups that they like doing the second. So what we did was we created a meeting rule for them saying motion shall be seconded. And when they appreciated that because they had one individual on their board that would constantly make motions that no one else wanted to hear. So what do? You adopt a rule. Now our motions need seconds, even though we're a small board. The Hawaii Real Estate Commission website does have some useful sources of information, and the links are spelled out in the handout that I provided. Okay, so feel free to check that out as you're at your leisure. Pending business. Sometimes there's pending board business that exists, and new board members are elected at an annual meeting of the owners. What Robert says about that is he says that matters temporarily but not finally disposed of fall to the ground. So he says once you replace any members on the board, as would happen at an annual meeting, then any pending business would fall to the ground. Roberts has different definitions of pending business than we do. However, the important thing to know is even if you just say, okay, we're going to drop what the board was working on, you can always reintroduce it. Okay? If the motion was already adopted, that's not pending. It's only if the motion was made and we didn't do anything with it. And that would be pending business that may be dropped from one board to another. Anything that was referred to a special committee of the board would still be active, and the special committee would still report back to that new board. So it is important for newly elected board members and officers to become familiar with pending board business after their election. That way they know if they need to bring something up again and reintroduce it as new business. So how to prep for board meetings. Board communications. So you heard John say a couple things about this email. We discussed email. There's also social networking. There's different websites that people use. Sometimes they have forums where they introduce things. But you got to keep in mind that board business must be transacted at a board meeting. There are exceptions for emergencies. Sometimes you have to do something by email. But if you have me on your board, I will be on it to make sure that we ratify that at a board meeting where discussion is allowed in case owners did have input on that issue. On my own condo board, we only meet quarterly, so there are times that we have to approve things by email, but we make sure always to put it on our agenda for the board meeting so we can officially ratify it, because that's the appropriate way to do it. You should be conducting board business at a board meeting, and it should be introduced by a motion. These are not official board business. They're not official board communications unless otherwise provided in bylaws or other legal documents of the association. Any decisions made that way are not official acts of the board members until it's done at a meeting. Sometimes people use these techniques. They actually use them to keep out owners. which is not a great idea and will lead to removal proceedings, as a couple of you can attest here. So it's strongly recommended that you, as a board member, you discuss things at a meeting where owners do have the right to be present. It also makes it difficult when you're conducting business by email or any of these means where we can't see or hear each other. We don't know the demeanor of other board members. It also doesn't encourage any sort of back and forth discussion. You know, email is one person replies and then the next person replies. It doesn't have that free flow of ideas that a physical meeting does. Keep in mind that as a board, you're the highest authority. Therefore, you have to use care to appreciate that this authority comes with a higher responsibility. And one of that higher responsibilities is to encourage that simultaneous communication between board members and often between owners. There are obvious exceptions to transparency regarding certain association business, especially things like personnel or pending litigation. Those are exceptions that should be used for the purpose of protecting the association rather than eliminating the inconvenience of having owners at your meeting. That's not an appropriate reason to go into executive session just because it's inconvenient for owners to be there listening to you. You should stick to the reasons that are allowed by law. So, my property manager prepares board packets for us before our meeting, and she's really great. She emails them to us ahead of time, so that way we can all review it beforehand. She used to mail it, but we requested to save money on administrative costs, and now she emails it, and they'll have printed copies at the meeting. So that way all of us have that opportunity, usually 3 to 7 days prior to the meeting, to review everything that could come up. And we know that when we get there, we'll also get that printed copy. So we don't have to waste time printing it, but we do have the opportunity to review, and we should. My least favorite thing is to get hired to run a board meeting, and then a number of board members come in and I see them open up for the first time the envelope that they were mailed with the board packet. And, well, clearly they're not gonna be ready to decide on it right away because they haven't even looked at it. They only opened it when they got to the meeting. And I strongly feel that board packet information should be read prior to the meeting. You want to be ready. It's like when you start work. So I start work at 7:45. I don't show up at 7:45. I show up before that because I need to make sure that my computer is on and that I am ready to work when 7:45 hits. It's the same idea with the board. You want to be ready to work as soon as that call to order time goes. Yeah, not reviewing those packets prior to the meeting is a constant complaint that I hear from property managers. So that's like the number one thing that you can do to get on the good side of your property manager is when they say, did you review the packet? Yes. Yes, I did. I had some questions about the financials, or I want to discuss the proposal from this site manager. So keep in mind that you're handicapping everyone in the decision-making process if you're not properly prepared prior to the board meeting. And that's a shared responsibility between the board members and management. When management doesn't give you the information ahead of time either, it makes it difficult for you to do your job. And so you need to hold your property manager to that standard as well. My boyfriend's father had a really good saying that he used to say, and he always said, on time is late. Early is on time. So I also apply that to my volunteer meetings. I figure whoever shows up early to set up the room, they don't have to break down the room. They can leave when we adjourn. Whoever didn't show up before the meeting came, so that way we could set up and start on time, they have to break down the room. So early is on time. For my own condo board meetings, I usually show up 15 to 30 minutes in advance. That way I can have everything ready to go in case owners do come and want me to look something up, want to discuss something, I want to be ready for them. Okay, there may be reports at your board meeting. Sometimes we'll hear a president's report, although honestly for my board, we usually hear that at the annual meeting, but other times we'll hear committee reports. When I was working on a house rules revision, it was kind of a committee of one, so I reported for that house rules committee. Be careful about long and involved verbal reports. This is why parliamentarians love reports in writing, because you don't have to say everything. You can just distribute a copy to everyone, and then there's no confusion on what you're reporting. Also, if you have any recommendations that you want the board to follow, any motions, if you put that in your written report, very easy to introduce the motion and make sure everyone has the exact wording of that motion. Some boards require all reports in writing, but For my board, we're kind of laid back, so we don't require it. However, if you are a larger board and you do have lots of ownership attendance, it's strongly recommended to request the board reports in writing. Then you could even go one step further and try to provide copies for owners when they come in. That way it doesn't have to be stated. You can just say it's in writing. Those should also be reviewed prior to the meeting if possible. Time limits again. So a lot of my board meeting rules also have time limits for reports, and additionally, time limits for any discussion that arises out of reports. Because sometimes we can end up talking about a certain report for a long time, but it doesn't result in a motion for action. And so my own condo board, we don't like to meet for longer than an hour. The only meeting that we have that goes longer than an hour is our budget meeting, and maybe we'll go an hour and 10 minutes, okay? We try to still keep it as concise as possible. So we're lucky at my own condo meeting, we haven't had to adopt rules, because we all kind of understand that. However, some of you may have a lot more owner participation than we do. We don't have a lot of owner participation, so we don't need it. But if you do have more participation, you may need to adopt rules. Which leads us to our board meeting proceedings. So the owner's concern area, also called the owner's forum. At annual meetings, we usually hold that after the meeting, if at all. But at board meetings, it's often held prior to the meeting start. And usually what we try to encourage boards to do is to focus the owners on concerns that are not on the agenda. So if you have specific agenda items listed, and always have copies of the agenda for any owners that come, it's really helpful. That way they know exactly what's coming up and they don't bring up items under owners' concerns that are later on in the agenda. That way they have this little moment. Usually it's 15 to 30 minutes, depending on, again, the size of the attendance of the group, where they can express concerns or suggestions for either the board or sometimes the manager to follow up on. So with the changes in the law in 2017, some boards have gone away from this item because owners can speak to every agenda item anyway. I still like to have a little bit of spot there, just so that way I can say, look, if you do have items that are not on the agenda, here's the time, because we're not going to discuss anything that isn't on the agenda. That way it'll make sure that it'll keep your board meetings concise, directed, and efficient. If you do have a forum, make sure to do time limits. Boards can also schedule forums separate from meetings. Some of the neighbor island groups that I serve, they'll have the owner's forum a day prior, and so that way they can have follow-up information at the board meeting itself. So it depends. Also, if you have a big issue, another group that I served that was doing a very large pipe replacement project, they had a series of town hall or owners forums meetings. So they could present the information to the owners, they could take in input, and then they could update their goals based on what the owners had said at prior forums and town halls. I recommend that board members get things in writing. A lot of people are willing to say something, but they don't want to put it in writing. However, if you want follow-up, the best way to encourage follow-up is put it in writing. You heard Gordon say the same thing. What do? You start with the email. Because that way you have it in writing and you can always print out the email and take it down. Hey, I contacted you about this item a little bit ago and I didn't hear anything from you, so I thought I'd follow up. There we go, but you do the first step in writing. So I generally request that for larger concerns that owners put them in writing, especially if they want an answer. If it's just something they're throwing out there, the landscapers are not doing a good job over here, not as important. But it's something that they want a response back. Hey, I wrote the board a letter requesting something and they never got back to me, then that's something you want to continuously put into writing. A lot of people forget that the board meeting is not an owner's meeting. It is a board meeting for the board to do its business, and again, that is their duty. They have to make the conduct of business a priority for every board meeting. So getting things in writing, that speeds up the process and makes it more efficient. Super important is to behave ourselves at meeting. Presidents have the greatest responsibility here. They have to be prepared for any procedural motion that could occur at the meeting. They also have to step in and rule certain motions out of order, and they need to know when to do that and why to do that. They may also have to correct a member. I've had to step in and ask someone to avoid using swear words. I've had to remind people to direct their comments to the chair, because even at a board meeting, you're still supposed to address the chair or the president when speaking. You're not supposed to go back and forth between the board members. It's one person speaks at a time, And technically, no one speaks without the chair recognizing them to speak. Okay, so the easiest way in a small meeting, raise your hand. You know, larger meeting, you might have to come to the microphone. Sometimes at some of my other volunteer meetings, they'll say, Madam Chair, Mr. Chair, you know, say something for recognition, or they'll state their name. Maintenance of this decorum is crucial to the success of any meeting. If the president or chair lets it get out of control, it disintegrates, and then no one will follow the rules, because then they see a couple people getting away with it, so they'll say, well, why am I waiting for recognition? This person keeps interrupting, and they're getting away with it. So sometimes I have to make someone an example, which sounds horrible, and it makes me feel like a teacher, but sometimes just that first person that you have to say, excuse me, you must address the chair before speaking. A lot of times everyone falls into line. So that first person, I'm sorry to that first person, but sometimes they're the perfect example of how everyone should behave. So I like this modern test for board decorum. So would you want owners to see you on YouTube? How about your family members? You know, so that's the idea. If you imagine that you're being videotaped and someone's going to put this online for everyone to witness, would you be okay with that? And you want to always say yes. Yes, I behaved myself properly. I followed all rules from the presiding officer, or as the presiding officer, I did everything I could to keep the meeting proper. So that's a good test for yourself. So especially because, you know, you don't want to be in an article on civil beat, you know, so that's not super fun. You need to make sure that you focus on the issues and not the people. A lot of times, certain meetings that I've been at, there'll be different factions, and they have such a personal problem with themselves already at this point that it becomes difficult for them to see that they're not discussing the issues anymore. They're only discussing the personalities. And just a bit of a reminder can be really helpful. What are we here for? We're not here to pick on each other. We're here to get the business done. And again, you're not getting paid to be there, so we want to be as efficient as possible. Focus on the process, not individuals. Executive session. So board members must understand when they can go into executive session. Check with legal counsel. There are different reasons listed in the law, but if you're not sure, shoot an email to your attorney if you're the president. Otherwise, you can always ask your property manager. Property manager is a good resource. A lot of times they know what can and can't be discussed in executive session. You must understand that importance of confidentiality. You don't want what you've said outside to show up in court, which it can, and I have seen it. So you don't want to disclose confidential information. Regarding executive session minutes, yes, you do want to have them. However, you want to keep them confidential. Usually you keep them confidential until that need for secrecy is not there. But you do want to have minutes of that. The minutes, again, they don't have to say who said what, but you want to get if any motions were approved, if you had to take any disciplinary actions against employees, etc. You definitely want to have a record of that. Sue Savio is here from Insurance Associates. She would say it's very important that board members follow executive session rules because it can lead to an increase in your directors and officers' insurance. And we've seen a bunch of increases the past year in D&O insurance, and it appears it's because there's been a lot of lawsuits. At one meeting I was at, Sue Savio talked about, I think it was over 100 lawsuits. She said the main factor was discrimination. So be very careful what you say outside of executive session. And be careful what you put in your minutes. So the minutes are the legal record of the meeting. They are not your newsletter. They are not a to-do list for your property manager, as enticing as it is to use them for that. The minutes are supposed to contain action, not words. Which means anytime someone says, I move, they put a motion out there, that should be in the minutes. If someone says, well, I kind of think we should do this, that doesn't need to be in the minutes. That's discussion. If it doesn't result in a motion, it doesn't need to be there. So the key is, and I'm still struggling with this on my own condo board, so it is a struggle, you want to have the minutes, the legal record of the meeting, and then have this, one property manager called it an action item list. And so what she did was she listed the type of item, what general topic, what needed to be done, and who was responsible. So I like the action item list, and that's a good way to keep it separate from the legal record of your meeting, which is the minutes. So there's also in my handout some more links to the Real Estate Commission's Hawaii Condominium Bulletin that talks about minutes. My father wrote a really good article about what should and shouldn't be in there. And we always state that we've been hired because of people putting too many things in the minutes. I've never been hired because someone didn't put enough in the minutes. I've also never seen litigation because someone didn't put enough, but I have seen a lot of litigation where someone put too much. So with minutes, less is more. Motions only. Conclusion. What are we trying to do? Have effective meetings while still avoiding the most common blunders so we protect our association and we protect ourselves. Prepare in advance, not at the meeting. And keep it moving. Sometimes I'll slyly elbow my president and I'll say, are we gonna have a motion on this? And she'll go, is anyone ready to make a motion? Everyone's quiet, so she'll move on to the next item of business. So keep the meeting moving. Sometimes we like each other, and so we will stay and we'll chat because we get along. But we want to keep the meeting efficient. We can always stay and chat after the meeting's over, after we get the business of the association done. All right, thank you for listening to me today.